Hi friends, let us understand the Rule 29 of the Income Tax Appellate Tribunal Rules 1963. And if you are planning to file the appeal before the Income Tax Appellate Tribunal, or you have filed the appeal before the Income Tax Appellate Tribunals, then in that case the Rule 29, that's the production of the additional evidence. And as per Rule 29, that all the parties to the appeal shall not be entitled to produce the additional evidence either in oral or the documentary or an affidavit or the witness to be produced until unless the tribunal considers it is important in deciding the judgment and in passing the judgment. In that case, if the tribunal allows, then it can be produced before the tribunal. Now the question is that, or it may happen that the tribunal may refer to the authorities to check the genuineness of the documents or the informations, and then consider it before passing the judgment. And in that situations, if the tribunal does not allow the additional evidence to be produced before the tribunal, then in that case there are two important judgments that it will be a beneficial or important to understand the in this regard. The one judgment, that is Honorable Madras High Court in case of RSS Sangamunga Pillai and Sons versus CIT, and in this case that Honorable Madras High Court has held that the tribunal has the discretionary power. Within its power, can admit the appeal, can admit the document additional evidence or the reject it straightforward. But this can't be in an arbitrary manner. So, if the tribunal thinks that it is important to consider the additional evidence or that has not been produced earlier, just to consider it and important in passing the judgment, in that case should consider it. But if the ITAT tribunal thinks that it's not important even to consider it, and then it can reject straightway. In this case, one more important judgment of the Supreme Court, that's in the case of K. Venkataramaya VA Sitaramaya Reddy, and in this case Supreme Court has held that as per the Rule 27 sub rule 1 of the Order 41 of the CPC, is that the appellate tribunal has the power to accept or admit or reject the additional evidence. But in some cases where might not be important, but if it is considered before passing the judgment, they should be considered before passing the judgment, and this is should be in a satisfactory manner as per the Rule 20.